Hello, everyone, and welcome to another episode of What We Can't Not Talk About, the podcast of the Austin Institute for the Study of Family and Culture. If you still haven't subscribed to our podcast, do so now. Also, if you like it and you still haven't shared it among your friends, you can do that right now. And if you're not a student, but you're a parent and you never donated to the Austin Institute, I think you could start. Now, that said, I'm thrilled to host today's episode. And the guest for this episode will be another friend of mine. I like to say is a friend. Before introducing you, though, to the friend and to the topic, I want to say that what we're about to talk about today, and funny choice of words here, is a topic that follows some of the ones we've recently discussed in our previous episodes. If you remember, couple of months ago, we discussed our finitude and the lost art of dying with Dr. Dugdale. If you haven't heard that episode, I'd encourage you all to go back and listen to it because it was great insight on the limits that we all have and the best way to face them. And then most recently, we had an episode on the decline in population almost everywhere and an aging population. And I do think that these two topics coupled together lead us, sadly, to the topic that we will discuss today, which is euthanasia and assisted suicide. We will look at it in particular through a Canadian lens. Unfortunately, Canada, and I say unfortunately because our guest is from Canada. Unfortunately, Canada is a pioneer in legalizing this practice. And so today we will have the pleasure, yes, to hear more about this from Brian Bird, a friend, an attorney, a former James Madison fellow at Princeton, which is where I had the pleasure of meeting him. So, Brian, welcome on our show, and thank you for joining us.
Well, thank you so much for having me, Marianna. It's great to be here.
So, right now you're an assistant professor, correct?
I am.
Would you like to say more about your background and your expertise to our audience?
Sure. So I'm currently teaching and doing research at the University of British Columbia in Vancouver at the Peter A. Allard School of Law, as it's called. And I've been here, this is now just finished my third year, started in the summer of 2020, right after the fellowship at the James Madison program. I'm about to transition from a role as assistant professor to a lecturer as of this July. So I'll be focusing more on teaching, although I'm sure the research will still continue very much unabated. In terms of my interest in this area, the topic for today, but more generally, I do a lot of writing and research on Canadian constitutional law, especially on our constitutionally entrenched Bill of Rights in Canada, the Charter of Rights and Freedoms, which has had a lot to say in this area and has in some ways been kind of the vehicle for where Canada is on euthanasia now in its at the current state of where things are. So my doctoral work was on freedom of conscience, on one of the guarantees in the Charter of Rights and Freedoms. That one hasn't had much to say yet in euthanasia, although it does come up, especially in areas of things like conscientious objection by healthcare professionals who don't want to participate in euthanasia. There's still more of a story to be told. But that's kind of how I got interested in this area, just by virtue of being, I guess, an aspiring constitutional scholar in Canada. That's where a lot of the heavy lifting legally is happening around euthanasia.
Yeah, and I do remember our conversations in Princeton as I was writing about the liberalization of assisted suicide in Italy, and you were telling me about the things that had already happened in 2015, if I'm not wrong, in Canada, and the path that Canada was following. So I think it would be interesting now to let our audience know what exactly happened in Canada.
Sure.
The reason being that what happened there might easily happen elsewhere, including where we are. So why don't you're a scholar, you wrote a very beautiful article about this on Quillette, very clear also, I would say. But we did mention the term euthanasia, and I know that the terms are a little different as they're used by the courts and legislatures. So anyway, if you want to guide us through, as you do with your students, in the topic and how things happened in your country.
Sure. So I guess the modern and current story of euthanasia in Canada really does indeed start in 2015, when the Supreme Court of Canada was asked by a number of claimants to invalidate the criminal prohibition on assisted suicide and murder to the extent that it encompassed or criminalized physician assisted death, as it's sometimes called, or medical assistance in dying. And the vehicle used by those claimants was a particular provision or guarantee in our Charter of Rights and Freedoms in Canada, the right to life, liberty, and security of the person, was used basically to channel an autonomy-based argument that part of life, liberty, and security of the person, of one's right to those three interests, encompassed or embedded within that was a right in certain medical circumstances, when certain medical circumstances had been achieved or reached or were in existence, a right to receive assistance from a medical professional to end one's life. And basically, in a nutshell, on the basis of that autonomy-driven argument, or a certain form of autonomy, the Supreme Court of Canada agreed that to the extent that the National Criminal Code, Canada has a national federal criminal code that applies across the country, to the extent that it did, criminalize either the assisting someone to commit suicide in certain medical circumstances, and I'll get to those circumstances are in a moment, or the actual direct kind of infliction of what would otherwise be murder, of killing someone through lethal injection, for example, to the extent that the Criminal Code of Canada prohibited those things, it was not compliant or not consistent with that right to life, liberty, or security and security of the person. And so the Supreme Court of Canada said that, gave Parliament a year, the federal Parliament, a year to revise the criminal code so that it would comply with that judgment. And a year later, so February of 2015, the Supreme Court of Canada hands down its judgment. Actually, about a year and a half later, June or July of 2016, the summer of 2016, Parliament does revise the criminal code to basically carve out an allowance for, as it's termed in the legislation, medical assistance in dying. So only certain people can provide that so-called assistance in dying. Basically, in a nutshell, certain doctors and certain nurses. The provinces, which have quite a bit of jurisdiction over healthcare, then step in and then can say more about the regulation of that, and they have. But basically, once we get to the summer of 2016, we have across Canada the legalization or decriminalization of what I often call the first version of euthanasia. It was indeed, in terms of what those medical circumstances are, just to wrap up this part, it was confined truly to the end of life. Someone who is suffering grievously from an irremediable condition with death on the horizon, death already approaching.
Foreseeable death, right?
Reasonably foreseeable death. They were the only ones that were allowed in that first version of euthanasia from July 2016 to avail themselves of medical assistance in dying.
Can I stop you here 1 second? Yes.
Yeah.
Thank you. It's so easy to talk to you. When to pause. So this version of 2016, the first thing that I want to ask you is, was this consistent with what the court had expressed? So we had a parliament that respected what the court had decided.
So literally before the ink had proverbially dried on that legislation of July of 2016, summer of 2016, there was another set of, there was multiple, at least one lawsuit that was started to challenge that legislation, in keeping with your question, as not going far enough. And the basic argument was that Parliament had not respected fully what the court had said in 2015. Now, I should say that I think most observers back in February of 2015, when the decision came out, viewed the court as indeed speaking only to a so-called right to euthanasia, to assisted death, indeed at the end of life, where death was reasonably foreseeable, So I think what Parliament passed in July of 2016, I think most observers viewed that as being consistent with what the court had said was necessary under its interpretation of the Constitution. But some people disagreed. And indeed, if you look at the decision, the case is called Carter v. Canada of 2015. if you read it, there is some potential ambiguity as to whether the right was broader than what Parliament passed about a year and a half later in the first version. But basically, the argument was it should not be restricted to reasonably foreseeable death. Indeed, a certain level of suffering that's determined by the individual as being grievous, intolerable, irremediable, but that this requirement of it being only at the end of life, if I can use that phrase, was challenged. And as we'll probably get to shortly, that challenge ended up being successful and thereby broadened quite quickly, only a few years after 2016, the right to be even, or euthanasia to be even more broadly available to more Canadians. So it's still a bit of a debate as to whether what the Parliament did in July of 2016 or the summer of 2016 was consistent. But I think most observers, I certainly, and many others, thought that what was being argued for in that litigation from 2015 was let's call it the end of life euthanasia. So it was a little bit of a surprise to some people, myself included, that fresh litigation would come so quickly after the initial version from summer of 2016.
Before we go to the second versus broadening and to the status of things as they are today, I had a couple of more questions about the court. So, coming from, a country where, as I wrote myself, and I was like, the court has made similar decisions, but there are certain things that I noticed about what it is in the Italian court, that there is a fear of the judges themselves that things could go too far. Was that in any way a fear among the Canadian court in 2015?
That's a good question. It's interesting, the decision, often whenever I have the chance, I refer to the first paragraph of the decision from 2015, really, literally paragraph 1 of the Carter decision really tells the story, and maybe to a certain extent answers your question, Marianna, that the court seemed to come out of the gate with a clear direction. I'll read it. It's just a couple of sentences. The court starts the decision this way, a unanimous decision by the court. It is a crime in Canada to assist another person in ending her own life. As a result, people who are grievously and irremediably ill cannot seek a physician's assistance in dying and may be condemned to a life of severe and intolerable suffering. A person facing this prospect has two options. She can take her own life prematurely, often by violent or dangerous means, or she can suffer until she dies from natural causes. The choice is cruel. That's the first paragraph of that decision. It seems to me that the court, to answer your question, I suppose, I didn't get the sense from that paragraph and from what followed that there was deep concern. I mean, I think that the court does have in its decision some references near the end to things like conscientious objection by medical professionals who don't want to participate in euthanasia, and has some relatively strong language saying that nothing in this decision compels physicians to be involved in this. That's still a bit of a battle as to how whether that'll be the case as the story unfolds. The court also did explicitly carve out and say that its decision in 2015 did not apply to certain things. For example, euthanasia for psychiatric conditions, although, as it turns out, we'll get to later, Parliament is actually going in that direction. Also, the court said that this decision has nothing to say about euthanasia for minors, although, as it turns out, Parliament is going
we'll
in
get
that
there. We'll
direction.
get before. But
sorry to go ahead.
But it's just striking. I think it says a lot about this. You're describing a court that is clearly a progressive court compared to other countries. Because I mean, in as bad as the Italian decision was, I know that there were pages and pages concerned with the, where such a decision and such a liberal, like broadening and the legalizing some form of assisted suicide where would have led. And related to that, you use the term euthanasia. Are we talking about in Canada, with reference to Canada? Are we talking about euthanasia? Or are we talking about assisted suicide?
Right. So as it's turned out, and I'll maybe paint the picture this way, the most recent statistics that we have for euthanasia in Canada are from 2021. The 2022 numbers should be coming out quite soon, but the 2021 numbers show that about just over 10,000 people, population of Canada, I'm going to be a bit off, it must be about 38 million or so, but over 10,000 people in 2021 just a few years after euthanasia first came to the country, availed themselves of this, of medical assistance in dying. We'll use that term to start. Virtually all of those, I'm talking like literally 99% of those cases are what we would, I think everyone would agree, is euthanasia. In other words, the use of a lethal injection by a physician upon a person that ends their life, as opposed to someone being handed the drugs and saying, okay, I will now take it myself and self-administer. So it is indeed, I think, and you can please, you have a lot of expertise on this, I know, Marianna, that it is basically virtually all what we would call, I think even traditionally, euthanasia. The use of, often it's usually in the form of a lethal injection upon the patient by the physician or the authorized personnel.
Yeah, which I think, throwing it out there, it does open, there is room for reflection over this fact, because it seems like people do not easily commit suicide, right? Mm. We might delegate in a state of depression or loneliness, or because I did read the statistics and like what are the conditions mentioned by the people that seek assistance in dying, but like there might be something to be said about being very careful for if someone is legislating on it, to make it that the person should always be the one responsible, right? And that maybe would decrease the numbers. But the other thing that I wanted to ask you was, before we go further, if this liberalization is based on this right to liberty of the constitutional charter, of the fundamental charter, it sounds like liberty for the Canadian court is a liberty that is autonomy, right? Completely autonomous decision. And is there in Canada a conversation about this interpretation as the one that exists in the United States? Are there originalists trying to say, well, when Canada had this, it was a different thing, and like that's not what we meant by liberty? Or as a constitutional scholar, I think that might be your bread and butter.
It's a great question. It doesn't seem like much of that discussion happens in the decision from 2015, and I can't think off the top of my head of many decisions where the court has gone down that originalist kind of route around this particular provision of the Charter, Section 7, which has been used in other contexts. It's pretty broad, right to life, liberty, security of the person. That covers a lot of potential.
Yeah, sounds topics. Like due process, right?
There's a lot there where you could go. So I think it's fair to say that. But that being said, there are some interesting scholarship in Canada around actually originalism occurring in certain Supreme Court of Canada cases without being labeled as such. So there's actually arguably probably more than most Canadian constitutional scholars, including myself, prior to reading that scholarship, knew was occurring. It's just not usually given that label in the same kind of highlighted, underlined way with a heading that you might see perhaps elsewhere. But I wanted, before I forget, Marianna, to mention, you asked about whether the court expressed concern in 2015 or was trying to show some caution moving forward. In fairness to the court does, for example, it gives Parliament a year. It actually sustains through what's called a suspended declaration of invalidity, sustained the unconstitutional state of the criminal code for a year, saying that this is a very complex area, clearly very nuanced, a lot of concerns. We want Parliament to take its time to get this quote unquote right, was what the court was saying, to make sure that they really think about the various kind of complexities at play. The court also does mention in other cases that other parts of the decision, that, safeguards will need to be, considered, that would be totally legitimate for Parliament and the provinces who have a lot of jurisdiction over healthcare to, carefully tailor a system to make sure that vulnerable individuals are not being given this kind of just easily, for lack of a better way of putting it, or without much effort. That's a discussion we can have as to whether that's panned out in a certain way. So the court does, in fairness to the court, there is mention and kind of mechanisms, I suppose, used by the court, especially that year, turned out to be a year and a half, sustaining of the unconstitutional law to give Parliament a chance to respond. But that first paragraph to me still really does tell the story. The court comes out kind of with a very strong message. It's also worth noting, just very quickly, that back in 1994, the court had considered, on a previous occasion, the constitutionality of those criminal code prohibitions that blocked physician-assisted death, and in a 5-4 decision of a 9-member court, found that, or upheld upheld at that time, but then revisited the issue in 2015, and then in a unanimous decision, 9-0, struck down these criminal code prohibitions to certain extents.
Just maybe some people in the audience might be interested. How are the justices of the Supreme Court? Are they elected? Are they political?
So they are political appointments, basically appointed by the Prime Minister. As it turns out in Canada, I don't know how long this history is of this, but there's a lot of consultation within the kind of the legal profession, academia, to try to see who might be a good option. But there's one thing that's interesting, there's no kind of Senate hearings, for lack of a better way of putting it. We do have a bicameral legislature as well, with the House of Commons and the Senate, but there's no, for a long time, there was absolutely no kind of presentation or appearance by the nominee, and then a vote. Once the Prime Minister has chosen, that person is assuming that they satisfy the legislative criteria. They need to be a lawyer of a certain number of years, et cetera, at the bar. Once, assuming that all those criteria are satisfied, they're on the court. In 2008, 2009, the then Conservative government did introduce something somewhat akin to, let's call it the Senate hearings, confirmation hearings, but there was no vote. It was more of like a meet and greet. Like, here's our nominee. Usually they'd be interviewed in a public hearing by a distinguished law professor, asked a number of questions, and then they would carry on to being appointed. But there was nothing that kind of hinged on that in terms of whether they would actually be on the court at the end of the day.
And is it life tenure?
No, it's till 75. So age 75.
Okay.
And there's interesting, many do go to 75, but a lot, especially in recent history, a lot of retirements prior to 75 as well.
Okay. Right. Now, that said, let's take the story from where we left it. So we were left at July 2016, and then the challenges to that law That's
right. So this challenge basically saying that this requirement of death being reasonably foreseeable should not be a part of Canada's euthanasia, medical assistance in dying scheme. Ultimately
So what would you need it to be? You need to have a disease that
so
causes
basically intolerable suffering. Has to be kind of
intolerable, of course, according to you, because
from a determination that I determined that this is just too much for me to subjectively to carry on with. And so the attack or the kind of the challenge was, why do we have this kind of confining of it? What if I'm someone who's 50 years old? I have a condition, maybe chronic back pain, that cannot be remedied. And it's got to that point where it's intolerable. I can't continue. I can't function. I'm on my lying down all day, can't get a job, et cetera, et cetera. Terrible situation. But my death, I could live for 20 years or more. Why am I not allowed to have this? Based on this idea of autonomy, basically the same principles that did a lot of the driving work in the 2015 decision. In 2019, a lower court, a court of first instance in Quebec, hearing one of these lawsuits that was kind of attacking the reasonable foreseeability component of the original first version of euthanasia, basically agreed, struck, and said that that component of the law of 2016 was not compliant with the charter and had to be read out of it. Instead of what was a surprise, well, maybe that in and of itself could be somewhat of a surprise, but what was particularly surprising is that the federal government did not appeal the decision to the appellate court in Quebec, and then ultimately to the Supreme Court of Canada to ask the court, listen, there's some ambiguity perhaps on this point in your decision from 2015. Help us out. That didn't happen. The federal government basically took up the 2019 decision of the trial judge in Quebec, and transformed it into what you would call is the second version of assisted death, of euthanasia in Canada, which was passed in part because of the pandemic, which happened, which kind of delayed things on a variety of fronts, but was ultimately enacted in March of 2021, so a little over 2 years ago, to take out that reasonable foreseeability requirement. There were some other changes, but the fundamental hallmark change was taking out reasonable foreseeability of death, which obviously widened eligibility for euthanasia enormously, tremendously in Canada, such that now you could have something like the person with the chronic back pain, for example. And we have had examples we can get to that, some of the stories that have come out.
Yeah, because I think that what makes it clear also for our audience to understand why a legal scholar decides to write about it. We all have our opinions about what is right, but there's something about, I think, the nobility of the legal profession which we are losing. But I still think it's a noble profession, that it was strongly related to justice. And you start reading some of the stories you mentioned in the article you wrote do speak of injustice, at least to me. So maybe, if you maybe mention, we will understand probably what prompted you to write about this, with you, sharing some of the stories caused by, the new definitions that the law has.
Yeah, so thank you for that. I mean, March of 2021, we have this much more expanded version of assisted death. And I mentioned earlier, as it turned out in 2021, we had 10,000 people availed themselves of that. That was a 32% increase from the year prior. I think in part because obviously it became wider, but also just the numbers from 2016, even within the first version, and then moving to the second version, have progressively continued. I'll be curious to see what the numbers are for 2022 when we receive them. I'm already lamenting that they might be indeed quite a further spike. We'll see how that looks. But where things really, I think, could end up being, looking back, an inflection point, a real perhaps turning point, hopefully from my perspective, you talk about our opinions, for the positive in Canada would have been about this time last year, 2022. We had about a year under the second version. And by that time, some stories were being, I want to say, put it this way, spontaneously reported by various media sources of Canadians who satisfied the medical criteria for assisted death. Their deaths weren't on the horizon, but they had a certain degree of suffering, irremediability, et cetera, But the kind of thread between all of them was that their socioeconomic circumstances, for lack of a better way of putting it, were a major driving factor for seeking assisted death. So the one that hit the news was indeed a fellow with back pain, severe chronic back pain, living in Ontario. He had been living in affordable housing for a while, or housing he could afford, and his rent went up. And he basically said he couldn't find anywhere else to live because of his medical circumstances affecting his ability to work and therefore to have income to pay for housing. And he said, listen, if the fork in the road is between being homeless or dying, and I am eligible, it seems, for assisted death, I'm going to pursue assisted death. I don't want to die, but between those two choices, I'm going to pursue assisted death. I happen to satisfy those requirements, those medical circumstances, so I'm going to go for it. His story hit the news, and because of a crowdfunding campaign that really, a surge of support for him. This is one of his more heartening stories. He was able to, basically be in a financial situation that averted him needing to, or his decision to pursue assisted death. So that's one example that hit the news. Another was two women who suffer from something called MCS. I think it's multiple chemical sensitivity. I may have the name wrong. MCS. Basically, in a nutshell, certain scents, certain household cleaners, for example, would cause severe problems for them. It'd be definitely diagnosed as such, like so the environment in which they were living really made a difference, and they couldn't find affordable housing or adequate housing that fit that condition. And both of them sought assisted death. One of which was euthanized. The other, last time I checked, has not, and I hope has not, and I hope that she's okay. So those are other examples of so back pain, kind of chemical sensitivity. Then what really, it's a bit of a pivot, but I think it's an important pivot. In that 2021 second version of assisted death, something that almost made it in, but didn't at the last minute, was including in the medical kind of criteria, the eligibility criteria, was to expand it to people who were suffering solely from mental illness. That did not make it into the March 2021 second version at the end of the day, but the law did include a sunset clause that would make it automatically available, further expand to people with mental illness as of March of 2020, of this past year, of 2 years, sorry, it would have been 2 years. From March of 2021, it was a 2-year sunset clause that would have kicked in this past March of 2023, to further expand to include people suffering solely from mental illness. As it turns out, in part, I think because of these reports that I was just talking about that came out last year, there was a surge of, I think, attention and awareness. I think a lot of Canadians, to be perfectly honest, weren't aware of how fast, maybe in part because this happened during the pandemic, people just not plugged in, et cetera, how fast this was going. And as I called it in one of my op-eds, seemed like kind of like a runaway train, was just going full speed. And as it turns out, the government has delayed further the expansion to people suffering solely from mental illness to March of next year, 2024. But they have said it's just a delay. It's not a abandonment of that. They're not canceling that plan. So we are on track for, let's call it the third version, to kick in next March, which would further expand it to individuals suffering solely from mental illness.
Yeah, although the hope is that articles like the one you wrote and more articles and more papers and more essay and more news might, prevent that from happening. You were also talking about opening this to minors.
That's right. So maybe before I get to minors, one thing I'll say is, I think when I said that maybe the reporting that started happening last year in 2022 and has continued pretty unabated. A recent one that came out just maybe about a month ago was that assisted death started to be there are cases of euthanasia now within prisons in Canada, which there's a whole number.
It's not that surprising, right?
Perhaps, yeah, but
who would prefer,
right? Yeah, so here's their choice. You can either continue life imprisonment, or there's in terms of vulnerability, there's a bunch of problems there, to put it mildly. But one thing that did come out amidst all of this, there are a bunch of parliamentary committees that have been studying where do we go next, basically. What's the next step after the third version, 5-10 years down the road. Last fall, so fall of 2022, with the expansion to mental illness being on the horizon for this March, potentially delayed, but before the third version had even come into play, a representative of the College of Physicians of Quebec at a parliamentary hearing suggested that euthanasia should be expanded to infants, newborns suffering from severe illness or disability, which would, and that caused a real stir, to put it mildly. Fast forward a few months later, to February of this year, February of 2023 or thereabouts, one of the parliamentary committees issues a report, recommendations of where we should go from here. And one of those recommendations is to basically lower the age. Right now, up until now, you have to be at least 18 to obtain, to be eligible for euthanasia. There is a age requirement, and I should have mentioned before, there is a consent requirement. You have to consent. Although suggesting it for newborns obviously takes consent out of the window. But anyway, this report said we should expand this, amongst the other potential expansions that are coming, to so-called mature minors. You think of the 16-year-old, the 15-year-old, the 17-year-old, who would like, for whatever, increasingly it seems like for whatever reason, we're not there yet, but one of the issues of this is just this runaway train seems to be going to a place where, as I've said before, you would be able to basically ask for euthanasia just because you wake up one morning and just you can't carry on. I was told, what really put things starkly for me in perspective is, I heard a parent say to me, that's a parent's worst nightmare. You because one of the things that the report suggested is maybe they would even recommend that parental consent isn't needed for the 16-year-old. So you have your 16-year-old who is suffering from whatever it might be, and a difficult situation, and you come home one day and they're gone. And it sounds like people say, oh, you're fear-mongering. That's another whole topic we could have, the slippery slope argument. People have been, from day one, from that 2015 decision, people saying this is where we're going to end up, is in a place where we now basically are in Canada. People were said you're irrational, you're fear-mongering, et cetera, and yet the proof has been, sadly, in the book.
Yeah, it's more than 10,000 people. And I mean, I did know the numbers because, I want to bring up why I connected this topic with the one that we addressed with Villaverde and with the declining population. We recently had this conference in Italy on the decrease in fertility and the aging population. And when you cannot pay pensions, you cannot pay public officials, you cannot pay for housing, you end up recommending, as I read the news about the veterans in Canada, yes, right, that they were suggested, well, why don't you consider killing yourself, right? Yeah. So what I did say in that occasion was, there are solutions, but they're not pleasant ones. And there are costs to our healthcare. There are costs to taking care of our parents. There are costs that even, what I would also would like to strike, if people think, oh, but this is never going to be my case. But when you know that you are a burden, you're 65 or you're 70, and you're a burden to your own kids who are already struggling, and this option is given to you and is given to them, there is almost a sense of well, I should, right? It's time for me to go.
Yes.
which just educates us to the opposite of what humanity is, which is right brotherhood in the crosses of every day, because the cross is not only the illness. And here I feel like I'm preaching, but that's how we live, right? Like we have crosses every day. Otherwise, we would not have all the mental issues we have on campuses, right? We have students that are healthy, wealthy, prepared to be, the champions of tomorrow, and they are depressed and sad. And our role of everyone, right, is to help them out of it. So in every case and in every stage of our life, it feels like the right decision is not to tell someone, well, just make up your mind about it. It's like, do whatever you want. It's like, no, I'm here for you.
Well, the point you made about burden, I literally was having a discussion with a friend of mine, and coming from a particular culture, where he said that basically what you just said, Marianna, that that because if this is made more available, he can easily envision whether it's his parents or parents of people within his culture saying, "Oh boy, I have become a burden to my children, and I therefore have some sort of a duty at some level to not be a burden anymore." And indeed, the statistics from 2021, this is all very public. They include a list of, I don't know, I presume this is happening in the application for assisted death for euthanasia, asking what are the motivating factors for why you're doing this. And in 2021, of those 10,000 deaths, 35 or so percent listed as at least one of the factors driving them to do this was basically because they perceived they were a burden on family members. So 35, a third of those 10,000, they may have listed other options. One of the other options was isolation. 17% listed that, loneliness. So this is happening even in the early days before. We all know how the law can normalize and be a teacher of what's, another thing, as you mentioned before, you made a very good point. I think the fact that this is housed within the medical profession, as I've heard one person put it, one scholar, the phrase will always stick with me: when you put the white coat on something, on a procedure, or there, it can help again to normalize or to legitimize at a normative, ethical, moral level what's going on. And you made the other point of between saying I'm going to take these pills myself and commit assisted suicide, or as opposed to let the person with the white coat do it to me because they do generally good things. That I think has a big impact. Picking up what you said earlier on, excuse me.
And this is a topic also that I would like to address in a future, not only in a podcast, but I think this should be a topic that we all read about, which is moral injury. Right. So that the sort of like quote unquote burnout of doctors, and the moral injury is basically what they, the way to describe it is like whatever doctors are pressured to do today that is against their own idea and belief of what it means to be a healer, right, and to be a doctor, and they are suffering symptoms that are very close to post-traumatic stress disorder because they're being required to do things that are not what they wanted to do when they went to med school. I mean, this is striking. I also want to make clear, right, that the reason to talk about these issues, the Italian and the Canadian speaking about this topic on the American podcast, is because these issues are international. What happens 100%. Right? So it doesn't stay in one place. It travels and it becomes normalized in one country. It becomes normalized in another one. But why? And I've heard stories of American friends who are also Canadian citizens that are considering, just taking a trip to Canada in order to do that. I don't know what the rules are for foreigners, if this is something that is only for citizens.
It's a good question. I haven't looked into that to be honest. I haven't seen any reporting around it, which would have, you imagine, especially would have come up if it was something that is not allowed to be happening. But I don't know. That's a good question. I should look into it. Yeah.
One thing that I will do is, together with linking to your article, I will link also to those public records that you mentioned, because I think those numbers are important for everyone to see. On another front, when the Italian Constitutional Court made its decision, I mean, it remained poetry what it stated, but it said, it's mandatory that before recurring to this to assisted suicide in the Italian case, there should be recourse to palliative care, true recourse to palliative care. Is that the case in Canada? What's the status of palliative care? Is that even provided?
So this has been a big discussion about, this. It was already happening before 2015, but the state of palliative care in Canada. And certainly, I think it's hard to find kind of consensus on how how good or how bad, or maybe it's more about how bad it is within the how bad spectrum in terms of how bad palliative care is in Canada. I think there is consensus that it's not where it needs to be. At least that it could be and should be a lot better. Certainly, once assisted death came onto the radar, the impetus to work on this issue and our advocacy around it, around palliative care, intensified, because of course, if there's that gap or a sufficient gap or not enough palliative care, that can make the option of assisted death even more palatable to someone, or make it seem like there really is no other option. And I think one thing I'll say is that, in terms of eligibility, there's no requirement that you have to try palliative care first or have to go through that. Basically, if you satisfy the medical criteria, you have a certain age, you consent, at least at this point of the current law.
Is there a wait? Like, do they reconfirm the decision like a month later, or like, do you know if there's?
So the safeguards have kind of changed over time, and in terms of how many people need to sign off. One person, two persons, and but the short story is that there are some cooling off or waiting periods. Those have, I think, the general trajectory has been from the first version to the second version. I think it's fair to say that the safeguards have become fewer on that front in terms of so the barriers have, I think it's fair as a general, without getting too much into the weeds, it's become easier. The hurdles have become less high or lowered, but you still have to, of course, make a formal application. A certain number of people who are authorized to provide assisted death have to sign off on it. One author that's worth looking at, I think he's a Canadian, but based in the US, is Alexander Raikin, Raikin. He wrote a piece on in the New Atlantic last December, which was very eye-opening in terms of how the whole industry, I hope I don't sound overly pejorative, of assisted death kind of operates. It's rather kind of insular, and they're doing, anyway, it's worth a read. Alexander Raikin's piece in the New Atlantic from last December. He's also, I think, written more. But the short story is, you don't need to say, I've gone through palliative care, I don't want to do that anymore. It'd be interesting to see how many people have actually done that. Although, for people whose death is not on the horizon, like the chronic back pain at age 50, I suppose palliative care wouldn't even really be an option. It's more, of course, for end of life. But one story that's worth mentioning very quickly is here in my home province in British Columbia, there was a hospice for end of life care, for palliative care, 10 beds, very small, had been operating, I think, since the early 1990s. It's a bit of a complicated case, but the short story is that hospice was told by the relevant health authority here in British Columbia that you have to open up to the possibility of euthanasia within your walls, within your hospice, or you'll lose basically your license, and we're going to take over the building, and it'll be run no longer as a private hospice, for lack of a better way of putting it, but now as a fully public. And to really show how bad things got, the hospice said, listen, okay, I know we do get at this point some funding from you, we've had for many years, we'll find a way to fund it completely ourselves. No public funds, but we'll continue to operate as a euthanasia-free zone. The government said, nope, we're not going to countenance that, provide euthanasia, or at least make it available as an option, or we're coming in to take over. And they eventually did take over that hospice.
Yeah, whoever is watching the YouTube can see my suffering face, but I'd encourage, the listeners to just close your eyes and imagine that you're sick and you're brought in a hospice, and you know that in the next room, people are brought to die. How does that make you feel?
Yeah,
right?
Absolutely.
Do you feel like you're being cured? That this is a place that you would call a hospice, really? Or are we going back to the darkest time in history that we thought were behind us? But as every historian knows, the dark times are never behind us, because good and evil, it's a constant fight. So
yes.
There's always a reason to be, an alert and be on guard. And with that on guard, I think I get, I promise it wasn't programmed as I didn't write it down, but I think I got to the end of that article you wrote, which mentioned, why you do this. It had something to do with Canada and what you would like your country to be.
Yeah, so I was invited to give a lecture. It's actually the lecture that formed the basis of that Colette article. It was a lecture at a local college here on the same campus that it's a Protestant evangelical college called Regent College, and they organized a talk, invited me to give a lecture on euthanasia. Is it a runaway train, or can we kind of stop this runaway train? And about a week before, maybe yeah, a week or two before the lecture. I hadn't actually written it yet. I was having difficult. It's a tough subject, you know. It's one of those things where I would say I'm pleased to give this lecture, but at some level I'm like, gosh, it's such a difficult topic. And I'm standing at, you know, a very quintessential Canadian event, which is a hockey game, and we're singing the national anthem. And I'm a Marianna will know this. I'm a bit of a musical guy. I like to sing, and so I sing the national anthem when the national anthem is being sung. And I think it's the most frequent line in our anthem. I think it happens 3 times, if memory serves. Is this line of, you know, "O Canada, we stand on guard for thee." And I think historically, I imagine that idea of standing on guard for the country would have been more kind of, you know, national defense oriented, to do with military, with wartime, et cetera, et cetera. I'd always thought of it that way. And maybe because I knew I needed to write this lecture, but somehow in the moment, I thought, well, when it comes to euthanasia and how things are going, we are woefully failing to stand on guard for each other as fellow Canadians. It just has been an absolute abject, if I can be honest, failure. And there's a lot of work that needs to be done. We are just letting this kind of individualistic, atomized kind of culture, which prevails, has led us to a place where, well, it's unfortunate for this person, but, you know, it's not going to happen to me. I'm okay, et cetera, et cetera. I'm being overly crass, but that you really, in this 15 seconds of that national anthem, hit me very hard that we're not standing on guard for each other. And so reason I do this work, or gave that lecture, wrote that article, doing this podcast, it comes from that place of wanting to try to, in a small way, be a part of starting to stand on guard for the country, and more specifically for fellow Canadians who are saying, listen, our lives have been rendered vulnerable, so vulnerable that it's getting to a place where this is so accessible, and there are so few supports for certain things, whether it's mental health, socioeconomic concerns, that my life is literally endangered.
Yeah, and in today's world, I don't feel like I'm of any value, right? Because if this is the vocabulary around me, I feel like I am a burden. Like I'm invited to think of myself as a burden. Last question. I mean, I talked about the nobility of the of the legal profession, but it sounds like it's not that noble if, you know, lawyers, courts are responsible for this status of things. So, do you think that where do you think we should do education in order to reverse the trend? Like, is it something that should happen in law schools? Is it something that should happen in the family? I mean, I know that, you know, it's a fight on a lot of fronts, but like, where do you think we have forgotten the importance of this kind of information, and we might, you know, do something to change?
Yeah, one of the points I made, I don't know if it ended up in the Quillette speech, but it's in the article, but certainly in the remarks at Regent College, was that, you know, this, in a way, it didn't happen just in 2015 and 2016. There had been this erosion prior to that, a setting of the stage to make this so much more palatable and for the slope to become very slippery, for the train to start to run away and to derail. And I think probably boils down to, in large part too, just how we understand the human person and what is the meaning of dignity. What is that word gets thrown around a lot, of dying with dignity. You know, these distortions of these fundamental concepts. And what does it mean to be human? What is suffering? What is care? What is dignity? All of these words have been distorted, co-opted, and kind of refashioned to make this worldview, quote unquote, make sense to many people. So I think that a lot of work, probably from, indeed, you mentioned the family, even from the elementary schools, you know, just how we teach of what it means to be a human person, to accompany someone, to care for someone, what all of these very fundamental concepts of what it means to live together, that needs to be rehabilitated. And I think it just didn't happen just in 2015 with just that one decision by the Supreme Court. That in many ways was kind of perhaps a culmination of or a product, an outcome of that softening, of an erosion of those principles over many, many years. So will it take a long time, I think, to fix it? So possibly, although, as I mentioned, that potential inflection point or turning point now, after the reporting from last year in 2022, what has happened is this is no longer, if I could put it this way, a kind of a conservative cause in Canada. You have people from, I would say, definitely across the political spectrum speaking out, people from the disability community, people from our Indigenous communities, people, yes, from religious communities, but from a variety of communities. And many of them I can think of off the top of my head would not describe themselves as conservative or religious, speaking generally the same, singing the same tune, that same standing on guard for thee, and we're not doing it right now. So then it boils down to, you know, who is holding kind of the levers of power. At this moment in time, the individuals who are probably driving this train, basically the federal government and our current federal government, they seem very intent on keeping the train going in one direction. But at least at the grassroots, from across a number of constituencies, if I can put it that way, there's been a bit of a groundswell to say, we can't do this. We need to roll this back. It's going to be a tough job, but I've been heartened to see a bit of an awakening. It's not an accident. I don't think that, I think it was $60,000 was raised for that fellow with back pain in like a month. These are regular Canadians putting their money where their mouth is, saying, no, this isn't the kind of society that we should have. So there are signs of hope, glimmers of hope, and hopefully it becomes a lot more than just a glimmer very soon.
Yeah, I think it's a reminder also for the parents that are listening, for me to be reminded of the importance of our work, where we mostly focus on like what it means to be human. It's even the title of like our summer seminar for high schoolers. But it's a reminder for all the parents listening that even the vocabulary they use in their conversation, and like not describing like being not physically the fittest as the greatest problem that can happen in life, like we'd be emotionally unfit, like it being emotionally unprepared to life is probably something that is more challenging and more problematic, and like valuing things different from grades and professional success, but like valuing, right, like other things in the people around us, making them understand that's important. So no, and also to say like not to blame just the court. If the court made a decision that the whole country didn't like, people would take the streets, right?
Right.
But that the fact that doesn't happen says how the court expresses the view of a majority. Yeah. Well, I want to do something I've never done. Since I have one of our summer interns in the room, who's also an undergraduate fellow here, I'm gonna ask him, we don't need to switch cameras, and I'm gonna ask if there is something that we left out that he would want to ask you, and then we can just have that.
Sure.
Okay, I don't know. I'm gonna report the question since it was in the room and it doesn't have the same very cool microphone I have. The question, if I understand it correctly, is more like, we did discuss like how our economic system influences this kind of decision. But could you see other factors, besides like the way the economy works, that might play a significant role in this changes and in these developments? Am I understanding correctly?
How specifically the economy does?
Oh, okay. No, sorry, rephrased. How specifically the economic system affects this. So probably, here it would be interesting to hear about whether healthcare is public or private.
Yeah, it's a good question. I mean, a lot of these stories that have been coming out, one of the common threads has been a lot of to do with housing, like housing concerns in terms of finding affordable housing or adequate housing. So kind of that's been a common one. Another one has been kind of mental health supports or psychological supports. Encountering massive wait times to get very kind of these kind of social kind of healthcare services, especially in that realm, in psychological or mental health supports. Also, we do have a public healthcare system, and that has, especially over the pandemic, a lot of cracks were kind of revealed in terms of the stresses or the challenges that our Canadian healthcare system has. It has many benefits from my perspective and merits, but there's been kind of an interesting realization because of the stresses that the pandemic put on it, that we kind of came to see some major problems in terms of, again, a lot to do with wait times, accessibility of having a family doctor, et cetera, et cetera. So a lot of it does seem to revolve around what's often called kind of social supports around healthcare, around housing, around shelter, very kind of basic, affordability, being able to afford food, just very basic things. And for a lot of people, then they also happen to have the eligibility criteria for medical assistance in dying, for euthanasia. While that is what gets them in the door, so to speak, from a legal perspective, what's clearly, it comes out in the stories loud and clear, is driving them is inaccessibility to the help they want to live. They want to carry on. They want to work through whatever struggles they're going through and forge ahead. That human spirit and that condition just kind of comes through in these stories. but they just feel they've hit a dead end for socioeconomic reasons, various socioeconomic reasons, and just get to a point where they feel like they're at a loss and they just don't know what else to do. And they see this option that's being made very. In some of the stories you hear people say it was easier for me to apply for and be approved for assisted death than it was for me to get a wheelchair.
Yeah.
And these are things like that. That's, I think, puts it really into perspective.
Yeah, it does. It does. And I mean, we could open a conversation about the welfare state, and one of our fellows,
Sure.
Catherine Pacalog, she defends free market, and at every possible occasion, and also private healthcare. But it makes us think like the welfare state can only exist and thrive when each one of us at least 3 children, and not when you have a decline in fertility and an aging population where, the state can literally not afford getting wheelchairs for everyone who is going to live over 75. So maybe there is more to be said about the economic side of things, and we might have this as a clue for another chat. Brian, unless I've left any, something out from things you wanted to say, did we not cover some of the topics?
It was a great conversation. Covered a lot of points, and I really appreciate you guiding me through it.
I appreciate what you told us and your expertise and your time and your article, which again, we will provide the link. Please continue to write and tell us what's happening just, a few miles north. More from Texas, but less from those who are listening from New York State.
Sure.
Thank you again, Brian, and we'll look forward to having you here in Austin or on our podcast again.
Thank you, Marianna.
Thank you. Thank you very much for listening, and we hope you enjoyed the episode of our show, What We Can't Not Talk About. If you did like the episode, remember to share it among your friends. Do not forget to subscribe, and if you can, please donate to the Austin Institute. Your donations make it possible for us to continue to do this, but above all, they support our local programming and the important, if not crucial, research of our fellows. Thank you.